come to 56. My lord, the bottom, the broad, my lord, the bold part. Similarly, Article 200 indicates another instance where the governor may act irrespective of any advice from Council of Ministers. In such matters where the governor is to exercise his discretion, he must discharge his duties to the best of his judgment. The governor is required to pursue such course which are not detrimental to the state. Now, my lord, come to Justice Krishna Iyer's judgment. Here, my lord, I may be pardoned, my lord, if I skip some words, because I may not be able to pronounce many of them. Because of language issue, my lord, not for any other reason. Kindly see, my lord, from the beginning and then the highlighted part. We declare the law of this branch of our constitution to be that the president and governor, custodians of all executive and other powers under various articles shall, by virtue of these provisions, exercise their formal constitutional powers only upon and in accordance with the advice of their ministers, save in a few well-known exceptional situations, without being dogmatic or exhaustive. Then again, my lord, Justice Krishna here also says that this is not exhaustive. These are illustrative. Cannot be. My lord, other side, my lord, other side, my lord, I am not, my lord, joining issue. Your lordships are right. But why I am emphasizing this is this. The state of Karnataka's written submission as well as oral submissions, written submission para 21 specifically says that only, my lord, I'll just read, my lord, it's a short para from the written submissions, your lordship need not open. Thus, the governor is bound by ministerial advice in the discharge of his functions. Article 163 requires the governor to act in his discretion by or under the constitution only, bold, underline. In the following circumstances, then articles are quoted. And, my lord, it must have missed their attention, my lord, I believe. Article 164 and 174 not quoted. Summoning of the assembly, calling upon the chief minister to prove his floor, it's not quoted. Because they say that only where it is provided under the constitution, there is a discretion. My lord, therefore, my lord, they treat these instances as exhaustive. I'll complete this. My lord, please see, my lord, Justice Krishna Iyer's minority view, my lord, though which my lord, his lordship says it's a concurring view, but this part, my lord, is not in tune with the majority. We have no doubt that the Smith's statement, so-and-so, regarding royal assent holds good for the president and governor in India. This is contrary to the majority view. The refusal of the royal assent on the ground that the monarchy strongly disapproved of a bill or that it was intensely controversial would nevertheless be unconstitutional. The only circumstances in which the withholding of the royal assent might be justifiable would be if the government itself were to advise such a course, a highly improbable contingency or possibility, or possibly if it was notorious that the bill had been passed in disregard to mandatory procedural requirements. But since the government in the latter situation would be of the opinion that the deviation would not affect the validity of the measure once it had been assented to, prudence would suggest the giving of the assent. Look, this is not what the majority has said. In what I have quoted, my lord, in para 54 to 55, 56. This part is a discordant note by Justice Krishna Iyer. That's all. Now, my lords, may kindly come to Lord. Lord, I have already told you, my lord, assisted your lordships by saying that all judgments which I have quoted here say that these are illustrative and not exhaustive, which were sought to be read as exhaustive, my lord. So I am not, my lord, going into it. Lord, now I come to, my lord, my second last point, my lord. That is, no mandamus can be issued to the governor or the president. And Article 361. My lord, this, my lord, I may take, my lord, 10 minutes. And, my lord, there is, in my submission, my lord, a direct judgment in A.K. Roy, where, my lord, this issue is considered. The question is, my lord, There are three categories of cases your lordships are dealing with when the governor's power is concerned. The first is purely executive power, namely the power under Article 356, etc., the power to grant pardon. That is, my lord, first case where your lordships have said that we have the power of judicial review. My lord, please don't treat this as an argument of arrogance that you cannot go into it. It's an interpretation that this aspect is non-justiciable. That's the as a constitutional proposition. Your lordships have said that even in cases of 356 or in Shatrughan Chauhan, your lordships have said the power to grant pardon within a particular time limit, etc. The judicial review is read, though very restrictively. Second category is, my lord, category like Article 200 and 201, which is legislative in nature, my lord, which I have already pointed out. Now, please come to, my lord, page 793, para 112A. The issue of justiciability of precedents and the governor's exercise of functions under Article 201 and 200 respectively must receive a nuanced interpretation and must not be conflated with usual principles of judicial review. The question of denial or of assent to a bill or the action of the governor to refer the bill to the president is not akin to or comparable to the exercise of his executive powers, such as pardon or imposition of precedence rule. Apart from being qualitatively different in terms of the functions, the following factors need to be considered. The suggested exercise of judicial review in case of Article 200 and 201, unlike other instances, involves three steps. Prescription of a timeline. 2. Quashing of a decision of the governor to withhold assent or quashing of a decision to refer the bill to the president. Quashing the decision of the governor to resort to first proviso instead of choosing either of the three options in the main part. And 4, a direction to withdraw the reference made to the president or returning a bill. Well, these are the four possible contingencies your lordship will have to resort to if your lordships were to exercise the power of judicial review and make this decision making justiciable. Lord 113. In none of the cases involving the exercise of power by the president and the governor has this court ever imposed a one-size-fits-all time frame, dehorsed the nature of the action and its complexity. Each case turns on its own peculiar facts. Now, please, my lord, read, and this is very important judgment, not cited by anyone so far, on justiciability. Lord, this is A.K. Roy versus Union of India. It's a constitution bench judgment. We may now take up for consideration the question which was put in the forefront by Dr. Ghatate, namely that since the central government has failed to exercise its power within a reasonable time, we should issue a mandamus calling upon it to discharge its duty without any further delay. My lord, kindly pause here for a minute. I'll just give the brief background. My lord, Justice Suryakant, my lord, was right, my lord, that fact situation will have to be given. In case of Article 200, the legislative process commences from introduction of the bill and ends with Article 200. It's a part of legislature. This was a case where a bill became an act, but the government did not notify it because it becomes effective only when the central government, from the date of it, is notified.
Official notification in the official.
And government was not, my lord, doing that, government of the day, and therefore, my lord, a writ was filed that direct the government to notify the act, meaning thereby to bring the law in force. Grant of assent also brings the law in force. This also brings the law in force, and therefore, my lord, I am reading this judgment. Our decision on this question should not be construed as putting a seal of approval on the delay caused by the central government in bringing the provisions of Section 3 of the 44th Amendment Act into force. I'm sorry, not even law. Even the constitutional amendment was not brought into force. Article 22. I am thankful to my learned. That amendment received the assent of the President on April 30, 1979, and more than 2.5 years have already gone by without the central government issuing a notification for bringing Section 3 of the Act into force, but we find ourselves unable to intervene in a matter of this nature by issuing a mandamus to the central government, obligating it to bring the provisions of Section 3 into force, even to the government. In my respectful submission, the threshold in case of the Honorable President and the Honorable Governor would be high. The Parliament has left to the unfettered judgment of the central government the question as regards the time for bringing the provisions of the 44th Amendment into force. It is not for the court to compel the government to do that which, according to the mandate of the Parliament, lies in its discretion to do when it considers it opportune to do. The executive is responsible to the Parliament, and if the Parliament considers that the executive has betrayed its trust by not bringing any provision of the amendment into force, it can censure the executive. It would be quite anomalous that the inaction of the executive should have the approval of the Parliament, and yet we should show our disapproval of it by issuing a mandamus. The court's power of judicial review in such cases has to be capable of being exercised both, please mark this, positively and negatively. And I'll say, my lord, why I'm requesting your lordships to mark this. If needed, it has that power positively by issuing a mandamus calling upon the government to act, and negatively by inhibiting it from acting. If you have the power, you have power of both positive as well as negative. If it were permissible to the court to compel the government by a mandamus to bring a constitutional amendment into force on the ground that the government has failed to do what it ought to have done, it would be equally permissible to the court to prevent the government from acting on some such ground as that the time was not yet ripe for issuing the notification for bringing the amendment into force. We quite see that it is difficult to appreciate that practical difficulty can possibly prevent the government from bringing into force the provisions of Section 3 of 44th Amendment after the passage of 2.5 years. But the remedy, according to us, is not the writ of mandamus. If the Parliament had laid down an objective standard or test governing the decision of the central government in the matter of enforcement of the amendment, it may have been possible to assess the situation judicially by examining the causes of the inaction of the government in order to see how far they bear upon the standard or test prescribed by the Parliament. But the Parliament has left the matter to the judgment of the central government without prescribing any objective norms. That makes it difficult for us to substitute our own judgment for that of the government on the question whether Section 3 of the Amendment Act should be brought into force. This is particularly so when the failure of the central government to bring that section into force so far can be no impediment in the way of Parliament in enacting a provision in the National Security Act on the lines of that action. In fact, the ordinance rightly adopted, no, that's on facts. It is for these reasons that we are unable to accept the submission that by issuing a mandamus, the central government must be compelled to bring the provisions of Section 3 of 44th Amendment Act into force. My Lord, now this is followed in these two judgments which I am not reading, but please see, my Lord, the position which will emerge. My Lord, and in a different context, my Lord, Justice Narasimha, my Lord, did, my Lord, indicate that. My Lord, kindly, my Lord, examine this. My Lord, kindly appreciate, my Lords. And I'm sharing this concern because your Lordships would be deciding henceforth what will be the course of action. My Lord, the 5-judge bench says that the power includes positive as well as negative.
No.
Do something. No, I'm sorry, my Lord.
Yes.
Court says that if we have the positive power to direct them, we also have, if we have negative power to prevent. Exactly, that's what, my Lord, I think, my Lord, I'm saying the same thing. I am unable to, my Lord, articulate the way your Lordship, my Lords, are doing it. I'm saying the same thing, that if I have the, if your Lordships are right, my Lord, I'm respectfully submitting that only. Now, my Lord, visualize the situation. My Lord, the judgment of this court, my Lord, in Tamil Nadu says that if the president doesn't decide within 3 months or the governor doesn't decide within 1 month, you come to us. Correct, my Lords? Now, state comes before your Lordships. The prayer would be, direct him to grant an assent. The question is, Can that be done, my lord? Can a writ of mandamus be issued to either the Honorable President or the Governor to grant an assent? But the problem doesn't stop there. My lord, somebody moves an application or files a separate petition that no, prevent the Governor from granting an assent and refer it to the President because there are repugnancies. The two petitions will be listed before your lordships. There can be, my lord, some MLAs who will file a separate petition that no, prevent the Governor either to grant an assent or refer it to the President, but ask him to return it to the House, because when the bill was passed, the Chief Minister was enjoying the majority confidence. Now we don't want that to happen. My lord, would your lordships be in a position to substitute what options the Governor would exercise? If your lordships have the power of granting a positive mandamus that do something, your lordships can also say that don't refer it to the President, don't return it to the House, don't withhold it. So therefore, quite timate actions, my lord, are not permissible, and therefore, my lord, this exercise is non-justiciable. Lord, that is my respectful submission. Otherwise, my lord, your lordships, it's not the state government only which can come. Citizens can come. Member of legislative assemblies can come. And, my lord, as it is, my lord, happening, therefore, threshold will be more. No, correct, my lord. My limited point is, my lord, would it be possible for this honorable court, apart from being, would it be permissible to deal with such situations where there are 4 petitions raising 4 issues? One says grant assent, one says don't grant assent, one says direct him to refer it, one says direct him to return it. Approved by the intervener. Your lordship's view is approved by the intervener.
Why?
He says yes, correct. He is no side, my lord. He is intervener. No, he didn't lay any path, my lord, but is not definitely middle. Anyway, my lord, let's not go into. The lordships are right. But, my lord, question would still be, and forget, my lord, this matter or reference, would one constitutional organ issue a mandamus to another coordinate constitutional organ when there is a discretion available, when there are 4 options, where there is no time limit prescribed by the Constitution, though otherwise time limit is prescribed. Yes, my lord, that applies to all 3 organs. I bow down.
As a custodian of the Constitution.
Lord, I'll not go into that debate, my lord. That's not, my lord, very. This is not an occasion.
We also